Members, Vice Chair Richards and member, where did he go? Our Miho could return. We can open up from the closed meeting. Okay, I'm gonna bring us back from our closed session. We talked about again our whether to ratify my decision to authorize the board attorney to pursue litigation to protect the board's current rulemaking. There was a Q&A session with the attorney. The attorney updated us on the status of that temporary restraining order application, and we talked about our next steps for litigation. So I want to open the floor to any motions from the board. One might be to ratify my decision to authorize the board attorney to pursue litigation to protect the current rulemaking.
I'll make a motion to ratify your decision.
Okay, moved by member Kalman.
I second.
Seconded by member Armijo. Is there any further discussion? Or any discussion at all? None? Okay, hearing none. Ms. Esther Armijo, would you please call the roll?
Member Armijo,
Yes.
Member Kalman,
Yes.
Member Eberline,
Yes.
Member Galuski, absent. Member Lewis, absent. Vice Chair Richards,
Yes.
Chair Paul.
Yes. So the motion passes. 5 yes, 2 absence, and 0 no's. Or sorry, 0 no's, 2 absences. A second motion might be to give me and the vice chair the authority to make decisions in this litigation on behalf of the board going forward.
I so move.
Moved by member Armijo,
I second that.
seconded by member Eberline. Is there any discussion on this motion? Well, thank you. That'll make things a little bit easier than everyone voting every time on every decision. So I appreciate that. Mrs. Armijo, would you call the roll?
Member Armijo,
Yes.
Member Kalman,
Yes.
Member Eberline,
Yes.
Member Galuski, Member Lewis, Vice Chair Richards,
Yes.
Chair Paul.
Yes, so that motion passes as well. 5 yes, 0 no, and 2 absences. All right, I believe that gets through our agenda for our meeting. Is there any other matters to discuss at this meeting, at this special meeting? Hearing none, I will call this meeting to a close. The time is 9:50 a.m.
See, we need, he's right there, Everline. Phyllis is-
Oh, there's Ellis.
Yeah, he'll come with you.
Right, if we can get settled, we'll continue. And Mr. Albrecht, if you can resume the witness seat. Either, I think Judy looks like she's still here. I thought. We'll see. She's on a business call. And I'll just remind you that you remain under oath. And I believe we left off with board questions. Were there any follow-up board questions? Okay. Vice Chair Richards?
Good morning, Mr. Albrecht. I just wondered, how many staff do you currently have and how many openings? So I'm curious to know, because I know you were talking about how long it's taking.
Yes, Vice Chair Richards, members of the board. Are you asking for the whole program?
For the air quality program,
So
just real quick.
for the org chart, there's 46 FTEs, 46, and we have approximately 10 vacancies right now.
Okay, so the 10 vacancies is included in the 46.
So yeah, there's 46 dedicated staff, but 10 is their vacancy of 10.
Thank you very much.
Mhm.
All right, thank you. If there's no further follow-up, I'll go down the line. Mr. Jans or Ms. Locke? Any examination?
No questions for this witness.
Mr. Paseniak?
Thank you, Judge Sanchez, and good morning, Mr. Albrecht. Just a couple of questions. Mr. Albrecht, does this, and I'm Gabe Paseniak, I represent community interveners, Dr. Sofia Martinez and Manuel Criollo. Does the city have any obligations under EPA regulations of the Title VI of the Civil Rights Act to ensure that its permitting does not have a discriminatory impact?
Yes.
Objection. This is Ms. Sona
Yes.
over here. Thank you. That was not within the scope of his direct testimony.
Well, I'm not sure if we have any direct testimony. I'm just going to allow everyone to question Mr. Albrecht. And you'll have the city will have the opportunity to do the same.
Thank you. So could you repeat your answer, please?
The city of Albuquerque is subject to Title VI.
And has an obligation, so the answer is yes. And does the city currently have any method of analyzing whether there is a discriminatory impact from its permitting processes?
Are you being specific to air permitting or just permitting?
Yes, to air.
Air permitting, there's no formal procedures at this time.
Thank you. And does the city currently have any kind of a regulatory mechanism in place that would prevent discriminatory impact in air pollution permitting?
I can't speak to the city as a whole, but regulatory in air, no.
Thank you. I have no further questions.
Thank you. Mr. Domenici?
Mr. Hearing Officer, Madam Chair, and board members. And Mr. Albrecht, did the city present in the docket it wasn't really a rule, but a statement of principles that the city suggested should guide perhaps this rulemaking or other ones that might take place in the future with respect to environmental justice?
If you're referring to the perspective that we filed with the board in August, yes.
And would that be docket 96? Well, let me just have this. Can you put up docket number 96? We can, perhaps could you scroll down a little bit so we can see most of the text on that first page? So, Mr. Albrecht, can you identify what this filing was?
Thank you for blowing that up.
I'll help you just, it says the city, Albuquerque, Bernalillo County Joint Air Quality Program, Notice of Environmental Justice Concepts.
Yes, that is correct.
And if you could scroll to the text, please, the attachment. Okay, I think it might be 96-1, if you could look for that. While you're looking, let me just add, what was the city attempting to do when they made that filing on July 18th?
The city file, oh, there it is right there, yes. The Air Board had asked us our position on this many times. We were asked to do a red line strikeout of the version 1. And version 1, when we evaluated version 1 that the petitioners filed for red line strikeout, we found that we were red line striking out almost the entire rule. And instead of doing a red line strikeout, we decided to put together concepts that we've been hearing, looking at what their objective would be. And we were trying to evaluate and come up with a process that would be enforceable and implementable by the department.
And do you still think this, well, could you scroll down, please, just a little, sir, so I can get the right reference? A little more to the very top. No, the other way, I'm sorry. So this is AQB Exhibit A to docket 96. And I know this is in the docket, Mr. Hearing Officer, but I would move admission of this document into the hearing record per se, unless all the docket is considered exhibits.
I believe they are.
Just to be absolutely sure, I just want to make sure I have noted I'd like to make this an exhibit.
It's admitted.
So Mr. Albrecht, big picture. Well, first I want to scroll through this just a little bit. If you could look at exemptions. So that's right in front of us, sir. If you could just scroll down slightly. So this is really something my client's focused on. So under exemption B4, it talks about relocations. So exemptions from this rule would include relocations for portable sources. And then it cites a definition from Part 41. Are you familiar with that?
Yes.
And you haven't, I don't know, have you listened to the testimony? I know you weren't here for large chunks of last week.
Yeah, we were listening in full via Zoom from City Hall.
Okay. Do you think it's important that the exemption for relocation of portable source remains in any additional rule should the board choose to enact one?
Yeah, we feel relocations of portable sources need to be exempted.
Okay. And then just some of this may be in this particular exhibit or just general questions, but as part of the proposal from the petitioners, there's an entire section that discusses the dispersion modeling. Are you familiar with that from, say, version 4?
Yes, from version 4, yeah.
Is there any problem with the dispersion modeling that the city has been using for decades being used for toxic analysis if the board chooses to go in that direction?
Can you restate the question again? I'm sorry.
Well, let me say it this way. Could the dispersion modeling that is already part of the city process, could it be utilized for risk assessment modeling if the rule goes in that direction?
Not risk assessment, no.
Could it be used for modeling of toxic, either HAPs or TAPs?
It could not be used for HAPs because HAPs are regulated under a different program. Air toxics, I know the state has an air toxics modeling program that we do not currently have.
But as far as the dispersion model itself, do you know if the state has a separate dispersion model they use for TAPs, or if they use the same one that is part of your guidelines?
I believe they use AirMod for air toxics.
And is that what you use?
We use AirMod, correct.
And I think there was some testimony, but I want to be very clear. Tell the board what document the city uses to govern dispersion modeling.
Yes, dispersion modeling for regulatory purposes are followed under Appendix W of the federal rules. The state of New Mexico also follows those. The state has their own air dispersion modeling guidelines, as we do as well.
How long have those dispersion guidelines that you have been in effect?
Oh, they've been in effect, I bet, 25 years.
Are they changed periodically?
They're changed when Appendix W or when the federal guidelines change.
Now, if I could, so would you be able to hit the highlights of this proposal that is Exhibit 96A, as far as what the city proposed? I know it's a complex question, but if you could maybe hit a few of the highlights.
The biggest highlight for this rule, and the important aspect of this rule, is that understanding what the community wants for environmental justice. It was very important to first evaluate, one, could this type of rulemaking be done under the Clean Air Act or the New Mexico Air Quality Control Act or our current board regulations? And that answer was no. And the reason is it's not like New Jersey, where New Jersey has a statute that allows for that type of permitting. The state of New Mexico does not have that, nor does actually at the federal level. So we wanted to propose something that was outside of the air permitting regulation part 41. And the whole idea behind this was for the applicant to have that community engagement and community outreach with their community. So if an applicant were going into a certain area, this whole document was for them to provide them with guidelines and kind of parameters of reaching out to the public, reaching out, looking at their concerns. But with that, we wanted to make it very clear that under these exemptions, there are certain permitting actions that, which you see up here, do not go under a public notice. So Part 41 has a requirement for to notice the public, not only from the applicant, from the notice of intent side for pre-application, but there's also our public notice that we give the public for 30 days. So all of these items 1 through 6, those are not subject to public notice because these technical revisions, emergency permits, relocations have already gone through public comment already.
Okay, let's put aside exemptions. Maybe I focus too much on them. I'm really trying to understand what if these guidelines or principles were put into effect, how would that change the permitting world really for permittees or persons that are subject to these for modifications or new applications?
Thanks for kind of elaborating a little more on that. The petitioner's first version, it appeared that it was a parallel process with Part 41. And the complications were, how do you rope that into Part 41? And in order to do that type of rule, you would have to actually revise Part 41. So what we wanted to do was remove those elements away from Part 41 and put it by itself. So the whole premise of this would be, and it's still duplicating, this would be a pre-application process. So this would make the applicant go through all the public notice, do all of those EJ screen types of evaluations pre-application, but would also incorporate our pre-application process through what we were perceiving to be our public health division. So the public health division could assist on the front end with this applicant to go through this process.
Does this proposal establish screening levels?
It does not establish screening levels.
Does it establish denial criteria?
No denial criteria. There is at the very end that suggests that the department may deny a permit, but there's no denial criteria.
Is there, would the department generate maps that would show perhaps overburdened or vulnerable communities as part of this proposal?
It's been a while, but I don't recall that we were going to generate. Well, I think we were. I'd have to look back at the rule. But one of the problems we had was it was a moving target because EPA's been moving relatively quickly on what type of screening tool to use. And one of the things that we had a problem with is, and we spent many meetings as staff and as a team identifying, do you use EJ screen? Do you use this tool? Do you use that tool? What's the criteria? Do you give it 1 through 7? You know, I've heard New Jersey, they give it a point system. So we had a very difficult time because we know that if you are very prescriptive in a rule, sometimes it handcuffs you. We wanted a rule that was going to be a little more in line of providing criteria where there was department approval of certain types, because we want to anticipate new tools that could possibly come into the mix. And at this time, I gave testimony last Friday that Nexus is out, which is yet a new thing. And we didn't want such a prescriptive rule or prescriptive criteria to evaluate.
Does this proposal enhance public notice and public participation?
I'm trying to get all my versions straight from the petitioner versus this one. No, I believe this one did not have additional public notice. It had more of, I believe it had more of the applicant working with the community versus an additional public notice.
How would the applicant work with the community?
The applicant would be, the whole idea was, like, again, our public health division would be kind of a liaison between the community and our permitting process, and that they would have the facility or the applicant actually reach out to the community that they're going to. So it would be the applicant engaging the community directly.
But how does that happen? Just so I have an idea.
The way we envision it is we kind of mirrored it after our stakeholder process, where the applicant, along with our community liaison through the public health division, would reach out to the community, give them notice, alert them that they're going into their area, go down, set up meetings, just have those discussions. If it's 1 meeting, 2, 3, 4, whatever it took to get a general consensus between the applicant and the community, and hopefully they could have a meaningful discussion that when the applicant goes for application, that it was sufficient for the public the community and also the applicant.
So in addition to the, this version of Part 72, do you recall the department presenting a strategic plan as part of their communications with the US EPA? If you could put that up.
If you could put that up, that'd be great.
This is the one that's the, I think it's listed under Title 6, November 21st.
In the meantime, I think Vice Chair wanted to interject. She had a question.
Yes, I may have to recuse myself if we're going into Title VI, depending on the
Oh.
substance of what you're questioning. But before that, I just want to point out, we do have this material in front of us, and I think myself and my colleagues have read much of it. So there's no need to go through things that are in the docket. We've read it, we understand it. Actually, I think I've read it probably more recently than you have, Mr. Albrecht. So just bear that in mind, please.
Okay, sure. I think
Now,
I'm
should I recuse myself? Is this going into a Title VI matter?
Well, I can tell you the question. You can maybe decide based on the question. Okay.
How deep are you going into this Title VI matter? Member Richards has recused herself from anything involving Title VI.
I'm just trying to show if the strategic plan that was in this communication is similar to the guidelines that we just looked at to show a consistent sort of position.
Member
the city.
Richards, this is a public document that he's going into.
Okay.
Yeah, it is. Well, certainly. So my main purpose, Mr. Albrecht, so first, do you recall the department responding to an EPA sort of, call it blueprint for settlement of the Title VI complaint?
Yes,
And as part of that, I don't need to go into all the detail. I just want to mainly just get a conclusory kind of testimony. Did the city propose a strategic plan that would set forth some environmental justice principles in that correspondence?
yes,
And are those similar to what is in that docket 96?
yes, very similar.
And so one of those, just to get the timing, the strategic plan was in November of 22. And
Member Richards?
I just want to mention for the record that Member Richards is leaving out of abundance of caution. She has recused herself from anything having to do with the Title VI matter.
So between November 21st, 2022, and when the city actually filed its statement of principles in June, was the city kind of on the same track as far as their approach to how they thought the issues really in this hearing should be addressed?
Yeah, they were very similar.
And I think I'm going to wrap up on this, but if you heard the testimony like you indicated, did you hear the testimony regarding mitigated and unmitigated emissions
Yes, I did.
from Dr. Clark? Have you seen any justification that why unmitigated emissions would be used as part of the proposed rule or perhaps what the city's proposing?
I see no reason to use unmitigated for modeling, no.
Thank you. That's all I have.
Member Richards, thank you.
Member Richards, is she?
Not sure if Member Richards can hear me, but she can return. I think we're done with that subject.
I texted her. She should be on her way.
Okay. And Mr. Rose, you're up next.
So I'll wait for Board Member Richards to be seated here.
Thank you.
Looks like she has coffee, which I could probably use some of. Mr. Albrecht, you just want to walk you through some questions, one on staffing, and I think you responded to Board Member Richards' questions that you had 46 FTEs in the air program in which you had 10 vacancies. Of those 46 FTEs, how many of them are dedicated to air permitting?
In the air permitting program, there's a manager, a supervisor, and 3 permit engineers.
And are all of those positions currently filled?
No, there's 1 vacancy out of there.
And I think you testified on Friday, which seems like a long time ago, in terms of the number of permits you currently process. And I think, well, maybe you can refresh my recollection about how many you process at any given time, or how many are pending at any given time.
Pretty much since I've returned from August of 22, the pending has gone down. However, in the last 6 months, pending applications anywhere from 50 to 60, and that's a pretty steady number at any given time.
And you testified on Friday concerning the time constraints that are built into the statute, and you walked us through that. Do you have any statistics, or does the department keep any statistics about how long it takes to process a permit application, determine it complete? Once determined complete, between the date of completeness and the decision, how much time on average, or how much time that the department's taking to process a permit?
We do have reporting tools that do keep the permit engineers and the managers in tune to where they are. One of the challenges with that is the system is it's archaic. But we're able to see, when the rule complete, when there's an extension required, and how long it takes. So yeah, that data is there.
And do you compile those statistically to determine on average how long it takes, or what percentage of permit applications are being processed within the time constraints spelled out in the statute?
To be honest, we have not been able to actually perform that specific. Low staffing in that area has been tough. I'll go back to, I was assisting in actually processing the permits, writing permits, reviewing them, and actually reviewing them and issuing. So staffing levels in that group, this is the highest it's been in quite a while. So, but that is definitely something that we keep individually within that section. But I don't keep ongoing statistics. That is definitely on the radar, and we're going to do. My hope is when we get staff, we're going to be able to look at that all the time.
Might be a good idea. And with respect to the proposal pending before the board, that is the petitioner's draft, have you evaluated that draft and determined what kind of staffing would be required to implement that proposal?
Yeah, and the first version, I'll just start with the first version. The first version, we didn't even know where to start because we just didn't know what that petition, what that rule even meant. More specifically, we were getting a fairly good idea with version 3, but then 4, 5, and 6 came out, and reviewing 6, we're just taking a guess. We're thinking it's going to be a toxicologist. It's going to be a data management analyst. There's going to be probably 2 modelers. We're looking at 3 to 4 at the very least for FTEs to implement this rule.
And have you evaluated what kind of budget increase would be necessary to implement the rule?
Again, we figured on, you know, 3 to 5 FTEs. Average salary, I bet it's going to increase the budget just in personnel, probably about $500,000 a year.
And has your evaluation been specific enough so that you could identify, for example, if you're going to need not just FTEs, but contract help in terms of administering this rule?
Yeah, specifically with respect to us within 60 days producing a map of overburdened communities. Then there's a 90-day where we have to do an EJ database. We're going to have to hire contractors to do that. We don't have in-house people that have the expertise to do this at this time.
And are you far enough along to give the board an estimate on what it's going to cost the department to actually perform those functions?
Roundabout estimates, if we were to get somebody on board to help us with our mapping, it's probably going to be a contract of, I'm just based on the contracts that I've seen, that contract could be $100,000 to $250,000. To get somebody on board for EJ database, I would say probably about the same. So we're looking at anywhere from $200,000 to maybe $400,000 to get those a contractor on board. Plus the timing, there's no way possible that we could get anybody on board with 60 days and 90 days. We're looking, even if I knew in my own program what the objective was, by the time I finish the scope of work, by the time, that's a 3 to 4 month process. That's if I know what's going on, but not knowing what's going on, it could double that time.
And I take it you currently don't have that amount of money in your current budget. What would it take to actually get an increase in appropriation to perform that task procedurally?
That's a great question. Right now we're mid-year. We've already been allocated a budget for this year. The other thing is there's no funding mechanism. I guess that's the more problematic thing for me is, okay, yeah, if we have to do it and we were forced to do it, we couldn't do it. One, because the current fee regulation does not allow for that activity. Part 2 fee regulation has specific objectives and by no means is public health and environmental justice in there. We would have to redo the fee regulation. We would have to put that as an objective in there. We would have to find out, okay, how is it going to be paid for? Who pays for it? Setting up the review fees, all those types of things that are consistent with our stationary source program right now, that has to be approved. Once we have that and we can prove that we have the monies, then the administration and the city council would approve it. So you're looking at least 1 fiscal year, if not 2 fiscal years from now, before you can actually demonstrate that you can fund it and get it appropriated.
And just to be clear, if the board mandated that you perform that task, I'd assume you'd have to move monies that are allocated to other programs to perform that task.
Yeah, as I stated, if we were to be mandated to do this program, we would have to move monies from somewhere, and it couldn't be from our Fund 242. It would have to come somewhere else.
And let me.
And I don't know where that is at this time.
Okay, let me walk you through the existing program. I think you said you listened to the testimony. Both Mr. Salente and Mr. Wade talked about the existing permitting program. And just for the record, talking about implementing Part 41 of the board's regulations. And there was some testimony concerning hazardous air pollutants and coverage under that rule. Could you explain how hazardous air pollutants are now covered and what kind of permitting is required for hazardous air pollutant emissions within the county?
Yeah, hazardous air pollutants, very different from air toxics. There is a list under 112 from EPA, and there's 188 hazardous air pollutants listed there. And with that, EPA has promulgated the NESHAP, the National Emission Standards for Hazardous Air Pollutants. So if your facility is subject to that NESHAP, those specific air pollutants, that's how they are regulated, it's how they're controlled. Also with the hazardous air pollutants, there's thresholds. The thresholds of 10 tons for any single or 25 tons for any combined. And so that's the other way they're regulated, either as an area source or a major source.
And let me draw your attention specifically, and I don't know if you have the rule in front of you, to 41.2, which is the scope, and 41.2B, which talks about emissions thresholds. And I'm looking at B3. And let me read it to you. It says, if a person proposes to construct a new stationary source or proposes a modification of a stationary source permit, and if the source will emit, when calculated at the air contaminant's potential emission rate, 2 tons per year or more of a single hazardous air pollutant, HAP, as defined by Section 112B of the Federal Clean Air Act, or 5 tons or more per year of a combination of HAP, then the proposed or existing source shall apply for and obtain a construction permit or construction permit modification as required by 20.11.41 NMAC before the person commences construction. So as I read it, and correct me, the threshold for going through Part 41 addresses hazardous air pollutants, either 2 tons of an individual HAP or 5 tons as a combination. And so that's the current program, correct?
That is correct.
And as part of the application process, both Mr. Salente and Mr. Wade testified about quantifying hazardous air pollutants. Is that the direction of, or is that at the direction of the program, that those be quantified in permit applications?
That is correct.
And are those the identification of HAPs and quantification then part of the applicants and the department's public notice?
Yes, they are.
And are there approval criteria for permits under Part 41 that specifically address HAPs? Or I guess in Part 41, it's denial criteria.
Yes.
And do you recall what those are when it comes to hazardous air pollutants?
Hazardous air pollutants, well, if they're subject to the MACT or a NESHAP, that's one criteria. I think that's it, if I recall.
Yeah, let me, for the board, I'm referring to 41.17, paragraph C, and I'll read it. The source will emit a hazard, and these are denial criteria for permits under the existing program. The source will emit a hazardous air pollutant for which no NESHAP applies if the HAP is emitted in a quantity and duration that may cause imminent danger to public health. So do you recall that provision?
Yes, I do.
And is that part of the department's current analysis when it comes to air permit applications?
Yes, it is.
Okay, I have no further questions of this witness.
Thank you, Mr. Rose. Mr. Trujillo or Mr. Mollenberg?
We have no questions.
Thank you. Mr. Calderon or Ms. Navarrete?
No questions. Thank you.
Thank you. Mr. Harris or Mr. Boutier?
Thank you, Mr. Hearing Officer, Madam Chair, members of the board. Just a couple of questions. Good morning, Mr. Albrecht.
Good morning.
Mr. Domenici asked you about the EHD's concept filing. Do you recall that this morning?
Yes, I do.
Do you recall roughly when that was filed?
July, late July, mid-July, yes, around July period. It was
And-
right after, yeah.
Sorry, I
Airborne.
don't mean to talk over you.
No, it's fine. It was during it was presented at an air board meeting.
And since that concept document was filed, have petitioners reached out individually to EHD or its staff or its lawyers to engage in a process for discussing those concepts?
No, they haven't.
Would EHD, instead of adopting an HEEI permitting process rule like is being proposed currently, would EHD be in favor of embarking on a stakeholder process, perhaps in 2024, to consider potential legislation in this area?
Yes.
Thank you. No further questions.
Thank you. Ms. Richards?
Morning, hearing officer and board members. Morning, Mr. Albrecht.
Good morning.
I'm first going to follow up on a few questions from other folks, then go back to the ones that I wrote out. You were asked about the cost to your office of implementing this, and I believe you said up to $500,000 for FTEs and somewhere between $200,000 and $500,000 for contract costs. Is that accurate?
That's the best we can come up with at this time. Yeah.
Have you performed any type of an impact assessment as to the overall cost that it would impact the city, your program, stakeholders? And by way of example, when EPA or energy, we pass a rule, before we can say we're going to pass a rule, we have a whole impact assessment.
We haven't been able to do that. And the reason is there's 6 versions, and to track and follow which version, what changed, what the implications are, the versions from November through current. So we're in December. 6 versions, that's kind of hard to identify. If we had something that was concrete, we would probably have a better idea, and I could actually go to our budget and our finance folks and try to figure that out.
And am I correct in understanding that you did actually request a copy of the rule the petitioners were proposing way back in November of 22?
Yes, the first meeting I was engaged in was November 14th, and that was down at the New Mexico Environmental Law Center with the petitioners, where they provided us the concepts of the rule on the whiteboard, but didn't have a hard copy of it. After that meeting, we did request a draft of it so we could review. A week later, November 21st is when they filed the petition. So no, we never got a draft.
I think I recall from Friday, Member Richards asked if you'd recently gotten a grant for VOC data from EPA. Is that correct?
Yes, yeah, there's a couple of grants. Yeah, there's and I'm not which grant. There's a couple of grants that we've got funding for.
That's what I'm trying to find out. What grants have you gotten funding for? That was my next question.
Yeah, there's 2 grants that the air monitoring group has received. One is from the American Rescue Plan, and the other is from the Inflation Reduction Act.
And what's the purpose of those grants?
The 2 purposes actually is to do VOC monitoring. Okay, there's one is about $115,000. That both of these were non-competitive grants, so the EPA had monies, and we got $115,000 for one, and I think it's about $105,000 for the other one, and it's both for monitoring for VOCs. Then, I'm sorry, I'll correct myself. One is for PM 2.5 up at the North Valley, and the other one is for VOCs.
Was the air program denied any other EPA grants or funding requests?
Not that I recall.
I wanted to ask you a few questions about the Cumulative Impact Committee. These are questions I've had for a long time because my IPRA responses have not been provided in 5 months. So I want to go through some of that. I understand that you came on board after the committee was created. Is that correct?
That is correct.
In the course and scope of your employment, did you review the status of the committee and its charge with your employees?
I was briefed on the status of that committee.
Do you have a general working knowledge of what the intent of that committee was?
When I got on board last August, what was conveyed to me was that the Community Impact Committee had been meeting, was being facilitated, and that they were, I guess there was a couple board members that were part of it, air board members. There's some communities, different community groups that were involved. EHD was involved. But when I got on board, it seemed like that committee was basically falling apart.
Are you aware that the committee first meeting was on June 9th of 22?
That's my understanding.
And you came on board only 2 months later in August of 2022?
Correct.
Do you know whether your staff relayed to the other members of that group that a rule would have to go through stakeholder engagement?
That is my understanding, is that EHD staff members conveyed that to them.
And are you aware that the primary attendees at that meeting were the Mountain View Coalition and Los Jardines?
That's my understanding, yes.
Do you know whether those different groups objected to other public and stakeholder engagement on the rulemaking?
I can't speak to that.
Did your staff advise you whether that was a concern?
I don't recall with that one.
Did the petitioners ever reach out to EHD to find out if any of the rule versions that they've submitted would be implementable by your department?
Are we talking about prior to their petitions or versions or in between?
Good question. Let's start with prior to.
I think Vice Chair wants to interject with
Yes,
a
ma'am.
comment or question.
Good morning. I think Mr. Albrecht said that he was not present at the EHD during the Cumulative Impact Committee. And I can tell you I was, and we've had a lot of transition in EHD since the onset of that, which was in 2022. Board members were not at that Cumulative Impacts meeting. It was really meant as a purpose to develop consensus of both EHD and the community members. And there was an open invitation to everybody. So I just want to clarify that because he already said he was not there. And I think to have him provide testimony on that is problematic.
Thank you. I would actually have to say that since he is charged with being the director of the program, he has briefings with the staff regularly. He is in a position to know what the concerns of the staff were, and exploring meaningful due process is kind of one of the critical issues here. We've had multiple briefs on it. It's been an issue that's been raised for the last 11 months. I had looked at the June 9th, 2022 agenda, and I did not see Ms. Richards listed on that list of attendees.
I think Chair Paul wants
Right.
to comment as well.
So I think we're confusing two things. So there was a committee of the board to work on the Cumulative Impacts Committee. So I think there were two, correct me if I'm wrong, there were two members of the board that were sort of assigned as to not break quorum, because 4 of us are a quorum. So 2 members could work on creating a Cumulative Impacts Committee. They did not sit on that committee. So they didn't work with the members of the public and EHD in those sessions to, help people come together. Hopefully that clarifies. Yeah.
And also just to add to that, it was called the Information Committee, and it was really to develop a scope. So that was the purpose, because the board had been wanting to try and facilitate better communication between EHD and the community, the affected community. So I think there are a lot of committees, and we were on the information committee. It was myself and member Coleman. We were not on any cumulative impacts committee.
Thank you. My questions
Sure.
only go to the Cumulative Impact Committee that with its first meeting that began on June 9th of 2022.
And
I
he
have
was-
the dates if you'd like.
I think he was
I-
not part of that process.
Yeah, I have the agenda and his employees were part of the process and they briefed him on this, which is why he's the appropriate person to ask the questions.
Limit your testimony only as to personal knowledge.
Do you know whether your staff, upon the convening of the Cumulative Impact Committee on June 9th, 2022, was there any requirement for your staff to send notice out to other stakeholders?
I can't answer that.
At any time, did your staff express to you that they felt they should be mailing notice out to stakeholders to facilitate the Cumulative Impact Committee?
Again, it's not my personal knowledge, so I can't answer that.
Did you have an opportunity to read any of the post-committee notes?
No, I haven't looked at the post-committee notes.
Do you know whether there was a deadline to providing a draft rule within the Cumulative Impact Committee?
I don't have personal knowledge of that.
Who would have personal knowledge of that?
It would be staff that were in attendance with that meeting.
So I recall the agenda included Ms. Trujillo. Would that be a staff member who'd be familiar? Maria Trujillo?
Not a Trujillo.
Okay. Do you know when the CIC was disbanded?
I can go by personal knowledge. It was right around the time that I came on board.
So around August of 2022 or September?
That's my understanding.
No more questions. Thank you.
Thank you. Pueblo of Isleta, Ms. Hidalgo?
I do have a few questions, Your Honor.
Sure, you may proceed. Pull the microphone down a bit.
Good morning. I just wanted to clarify because I'm not sure if I understood this. Did the petitioners ever reach out to EHD after the rule was proposed?
I know there was a meeting on December 5th.
And do you know if there was, I guess, do you know any other details of the steps that EHD took to discuss like the implementation of any version of the proposed rule?
Objection asked and answered.
Overruled. Go ahead.
Ask the question again, please.
Can you discuss in detail what steps EHD took to discuss the implementation of any version of the proposed rule
Are you referring to the December 5th meeting?
or any other meetings?
December 5th meeting, I wasn't in attendance to that.
But there were times that there were multiple times petitioners did meet with EHD.
Yeah, we met with them during the pre-conference meetings and hearings.
And you don't recall whether there were any other meetings in September or October of last year or of this year, I apologize.
Objection as to form. It's confusing. I don't even know what she's seeking an answer to.
If the question's clear, you can go ahead and answer.
Again, I know that the hearing officer, the previous hearing officer established pre-hearing meeting dates. And there were confidential meetings as a group of all parties. I attended those. And I also attended 2 other meetings that were at City Hall.
And outside of the pre-hearing meetings, was there any attempts by petitioners to meet outside of those pre-hearing meetings?
I can only speak to those meetings up till September 4th.
And I wanted to direct your attention to some emails that I know petitioners had sent to Nathan, the city attorney. If I may approach the witness, Your
Go
Honor.
ahead, go ahead.
Objection. Those documents are not in the record. It's improper to bring them before the witness at this time.
Which documents are you referring to?
Mr. Hearing Officer, these can be used impeachment, test the veracity of the witness, and also to refresh his recollection.
What documents are you referring to?
And Your Honor, they're just emails with the petitioners, with the city attorney discussing showing that petitioners did actually reach out to the city to try and meet with them to discuss the implementability of the rule in all of its versions.
You're asking him to review this document?
The emails, Your Honor.
Okay, I mean, it can be used to refresh his recollection if you're trying to establish some.
Yes, I am. Thank you, Your Honor.
And Your Honor, I'd still like to continue to object because there's not been a proper foundation for this. The attorney hasn't broken down the time periods, and I think Mr. Albrecht has testified very clearly. There is a before version 1 was filed and an after version 1 was filed. At this point, we have no idea what she's trying to refresh his memory on because her questions haven't been clear as to that point.
I'm going to allow it. Rules of evidence and civil procedure do not apply in these proceedings. Go ahead.
And Your Honor, I will just point out that this email is from September 21st of 2023 at 11:48 p.m.
Show it to him.
If I may, I wasn't involved in this process from September 4th until about November 1st. So I can't speak to that email on that date.
If it does not help, please let us know.
And Your Honor, may I ask for a copy of this document, please? I'd like to be able to review it as well.
The witness is signifying that he has no knowledge of this. You can continue without it.
And just a couple more questions. I just wanted to know whether or not portable sources are exempt from the state toxic air pollutants rule.
So you're speaking about NMEDs, air toxics rule?
Yes.
I could not speak to that.
And then just one last question. Do you know if the city currently participates in consultation with the surrounding tribal communities, specifically Isleta, regarding permitting?
That is not under my purview.
No further questions, Your Honor. Thank you.
Thank you, Ms. Hidalgo. I'm going to move to the pro se party, Ms. Semino. I don't see a hand raised, so I'm going to assume that she has no questions of this witness. City of Albuquerque HD, Mr. Mulvihill or Ms. Sona. You may proceed.
Good morning, everyone. For the record, my name is Kelsey Sona, and I am an assistant city attorney with the city of Albuquerque, representing the air quality program. And if I may, I'd like to do a brief redirect with Deputy Director Albrecht. So there's a couple, just 2 or 3 areas I want to touch on. Deputy Director, you've been asked a couple times about staffing, and you testified that 3 to 4 staff, 3 to 5 staff would be needed to implement any version of the proposed rule. Do you recall that?
Yes, I do.
Can you briefly share how new positions are created within the air quality program and what's required for them to get approved?
And I kind of touched on this on Friday and also earlier this morning. And I'll use it in the sense of if this was a rule that we were going to implement, the first thing we do is, okay, why are we implementing this rule? The second thing we would do is, okay, what's the funding mechanism behind it? How do you fund this? Once we've established the rule, the objective of the rule, and a potential funding source. Prior to going out to stakeholders and reaching out to stakeholders for this rule, we would have identified exactly what this rule would mean as far as staffing. So we would prepare a fiscal impact analysis, which we're required to do for any type of like position. We would establish what level, meaning is it a scientist, senior scientist, is it a manager, a supervisor? We would identify the positions, we would identify a salary. And with that, we would have to produce what we call a white paper during budget call. So budget call is usually typically in December, and we would have to present all those for the next fiscal year. So in this case, we wouldn't be, just based on the timing of it, we would not be able to do these white papers. So I would have to do up to 3 to 5 different white papers that would need to go to first the department director for approval. And then it needs to go to the administration for approval. And then ultimately it goes before city council for approval. So there's a couple steps where you can ask, but sometimes you are denied.
Thank you. I want to turn to another subject that there was a little bit of uncertainty about. Do you recall last week on Friday testifying about ex parte communications and communications with petitioners?
Yes, I do.
Okay. Is it your understanding that ex parte prohibitions apply to communications with Air Board members?
During rulemakings, yes.
Okay, and not to the parties themselves?
Yes.
Okay. And so when you were testifying earlier about communications and you were being cautious, was your testimony about ex parte communications because of the contested issues and the caution that the city was taking with yourself and staff regarding communications with board members?
Yeah, and when Chair Paul was asking the question, I was actually going back in time and putting myself in a position where Chair Paul and I were having a discussion, which would have been ex parte versus the question she was asking the parties, and I got confused. So just wanted to clarify with that. Yeah.
Okay, and so
out of abundance of caution, I've told myself and staff to be very cautious of who you speak with about this, especially during rulemaking right now.
okay, and so for the question that I think Chair Paul was asking, to get to that, are you familiar with the ethical obligation that attorneys have to not speak with persons represented about the representation?
Yes.
And so when you were talking about communications with petitioners and being cautious, was that the principle that you intended to mention instead of ex parte contact?
Yes.
Okay.
It can be quite confusing, and in the moments, yeah, even in staff, it's like, can we talk to them? Can we talk to this person? So out of abundance of a caution, yeah, I misspoke.
Okay, and so just to be clear for the record, you're correcting your testimony from Friday on that issue?
Yes, I am.
Okay. Just 3 last brief questions. Is the perspective that EHD filed in this matter in a form ready for adoption by the board?
Right now, no. I think that it's a very, very good start. And we did share that with the petitioners. We've shared it with all the parties. We shared it with you as the Air Board. We felt at the time, I mean, July, we're already 5 months past that. There's a lot of developments that have occurred since then. Again, I'll go back to my example last Friday with Nexus. That's a new tool that EPA is coming out with. It's a very good start. And I think through the last 5 months since it's been filed, there's a lot of room for improvement on it. But yeah, it's a very good start.
Thank you. And hopefully last question. What is the staff and resource demand required for applying and managing federal grants?
managing federal grants, it depends on who obtains those grants. I can tell you our Amarantin group does a very good job of it because they're constantly, that's where their funding comes, is federally. So if you're referring to other divisions, it would be a little bit, there's a little bit of work that need to be done. I guess, are you implying like permitting, or if we apply for those grants?
So the question is just generally, is this a resource intensive activity or is it a fairly simple, easy activity for the program to do?
It would be a resource intensive. And I'll use an example. When I was down at the airport, I did a lot of the FAA grants for many projects, and it took a lot of work, and a lot of resources, a lot of financials. That is something the air programs does not have right now.
Thank you. No further questions.
Thank you. There
Just
may
to
be some
follow
follow-up questions or comments from the board before we release this witness.
Mr. Hearing Officer,
Are there-
I have a comment. I'd like to make an offer of proof also when the time's right.
Okay, but let's get done with the board first.
I have a few, but do any other board members have questions? Please, Vice Chair Richards.
Just two questions, Mr. Albrecht. Thanks for hanging in there with us. I was looking at this 96.1 docket because we're told to use dockets. And it's a notice of environmental justice concepts, Exhibit A. And actually, you mentioned in here that EHD will be developing a map within 60 days. It looks like it's pretty much identical language to that of the petitioners. And so when you were questioned about it, you said, no, that's prohibitively expensive. I know the city has a GIS department, so I'm wondering why the city recommended it. And then when the petitioners recommended it, you said, no, that's out of bounds.
You're gonna laugh at the answer.
Okay.
We just took a guess. When you put things in like that, you either put 60, 90, or 120 days, and we just put 60 days. And we understood that was going to be a topic of negotiation based on what the actual tool looked like. At the very simplest level, 60 days. At the very onset, it could be up to 180 days. So it was just, it's like putting an effective date in the rule, effective date being November 1st. So it was a date that we actually we came up with. It was nothing that was based on our perception of where we were at the time. It was just the numbers thrown out there.
Okay, and it sounds like at that point in time, were you concerned about the funding necessary for it? Because it seemed like since it's in your proposal, perhaps you were thinking of a grant or using the city's GIS team to do this. I'm just curious to know.
If you really read what our perspective in those concepts were, it really put a lot of the burden on the applicant. Okay, so there wasn't extra air dispersion modeling to review, which we'd have to do under this current version 6. There's a lot of duplication in version 6 that we actually warned the New Mexico Environmental Law Center and petitioners that anything that's going to duplicate Part 41 would be a non-starter for us, because the duplication. So this concepts does not have air dispersion modeling. It puts the applicant, the responsibility of the applicant to do the screening, to look at the health assessments and all that stuff. So it would not be department that would be doing this like version 6 is.
I'm just referencing the actual mapping that we were talking about, where you were saying you'd have to get an outside consultant and it cost money. Yeah. So I'm thinking perhaps you were also thinking that same thing when you were developing this recommendation.
That we would have to get a contractor. That is correct. I'm sorry, I misunderstood.
Okay. Yeah, I've been involved in the zoning side of the city, and I know they have an exceptional GIS team. So I was just wondering, why can't we use?
Well, and the reason why I can't use internal GIS is because there's really nobody that understands the EJ components and the EJ screen. So we were going to actually hire somebody that would actually have that type of, that's what we're looking at. That was the thought process.
Okay. And then just real quick, you mentioned, I don't know, you mentioned that you have a budget, but I'm not sure what it is for your permitting section, do you have those numbers and are you allowed to provide that to the board?
I don't have it specific for the permitting. It's just an overall budget for the whole program. Like I stated, the Fund 242 has three funding mechanisms. One is the Title V operating permits. The second is minor source permitting. And the third is fugitive dust program. So all three of those are under Fund 242, which is the enterprise fund. And it has each one of those has different activity numbers. And as you know, as you might or maybe not know, permitters, there's Title V people that are dedicated to Title V. We have inspectors dedicated to Title V. So their positions are out of those like Title V fees. The same is true of fugitive dust. Most of it are the inspectors. In a minor sources, which is our operating, they call it operating under the budget. Those are the minor source folks. So the permitters that are dedicated there are paid out of that. And then the inspectors are paid out of over here. So it's not, you don't have a permitting budget for just one activity. There's three different positions coming from three funding sources.
And so for the 242, I forget the number you said for.
Yeah, 242. It's Fund
Yeah,
242.
what is the budget for that?
It's around, for the whole program, it's about $4.3 million.
Thank you. That's all I have.
Two questions, very quick. What's the start of the city fiscal year?
July 1.
And then to reiterate, EHD has no environmental justice rule that you are recommending to the board to adopt in this hearing.
No rule per se. I mean, we have the concepts, which are a good start, which it definitely needs a lot of work and a lot of stakeholder process. And I think that's a very good start. But no, we don't have a proposed rule at this time. It's everything's too fluid. There's a lot of things that are even out of this hearing, you hear different things. So
thank you so much for your time.
You're done, Mr. Albrecht. Thank you very much.
Can I just, before we part,
Hold on just a moment.
I just want to really, I feel it's important to thank you guys for supporting the facilitation of the Cumulative Impacts Committee, the pre-hearing officer, and just your support for Ms. Esther Armijo. She's wonderful, and we just super appreciate everything that you've done.
I did forget
Appreciate that.
Mr. Domenici. Do you want a point of clarification?
When I was questioning Mr. Albrecht about docket number 96.1, Vice Chair Richard indicated and sort of asked me to refrain my questioning, indicating that everyone was familiar with it on the board. I want to just confirm that it is not part of any notice of intent. It's one of 229 docket numbers. It was very difficult for me to find it when I wanted to look for it. So I don't think that's accurate that everyone on the board is familiar with it because it was not part of an NOI, and those were massive. And I do think the board certainly tried to review all the NOIs. Given that, I would like to at least go through the key sections. This will take less than 5 minutes of this rule because some of the terminology used is very applicable to some of the testimony we've heard. And I can do that through questioning, or I can just do it myself on the record. But I think it really is an improper statement to sort of expect the board to know this rule since it was not part of any NOI.
Chair Paul?
I'll just also put on the record that I have multiple times throughout this year-long process asked board members, and you can see an email, I mean, they're attorney-client privilege emails, but this board has been informed to keep up with the docket. And so everyone has read everything. I can't speak to individual folks, but I know they've been given a reminder on a frequent basis to start reading the docket as it started and to read it up to today. So I just disagree with the idea that we don't know what's in it. Thanks.
Member Lewis, you've raised your hand. Do you have a comment or question?
Yes, I have a question for Mr. Albrecht.
Go, proceed.
I wanted to know if the department or the Air Quality Division is providing or has any relationship with the state's environmental public health tracking system. which collects a lot of the data that are generated for the proposed screening tools, either by EPA's version or the petitioner's version, and tracks exposures and health concerns throughout the state. It's been in place for about, probably 15 years, 10, 15 years. And I'm just wondering if the city has a partnership with them to share data, or if you're aware of that system.
I'm not aware that the city has a partnership with that entity you're speaking of.
Okay, it's the State Department of Health. Okay, thank you. Whoops, I'm sorry, I was trying to put that down. Okay.
Thank you, Member Lewis.
So for my offer of proof, I'm going to make this very abbreviated. I appreciate the comments from both board members. I still am concerned that for purposes of this hearing, it hasn't been clear until now that board members are considering matters in the docket as opposed to the notice of intent. And that's
Objection, Mr. Hearing Officer. The chair has spoken on the issue. It seems closed, resolved. I'd also like to add petitioners are concerned about the implication for Mr. Domenici that Ms. Richards is not being forthright or is concealing something in this process.
I wasn't indicating any concealing. I'm just indicating there's a clear notice of intent process.
What's the docket number again?
96.1.
All right.
And all I was saying is that it wasn't part of the notice of intent.
I trust that during the board's deliberations that they will pay particular attention to that docket number.
Thank you. That's all I have.
Thank you. If there's nothing further from the board, I think you.
Hearing officer, this is Ms. Sona.
Yes.
May I ask two brief redirect questions given Member Richards' questions of Deputy Director Albrecht?
You may. I'll give you that leeway.
Would you like me to go to the podium?
If you want to ask them from there, that's fine with me.
Okay. Sorry, Deputy Director, I'm behind you. Regarding the typical process that EHD follows for drafting regulations, doing the pre-petition process, and putting everything together into a package, does it determine prior to filing a petition exactly when and how it can implement the concepts it puts in a rule?
The answer is yes. I think that's one of the main differences between this petition versus what a petition would look like from EHD. EHD, I'll just kind of run you through, is we identify a rule that needs to be made, and we identify what the objective and the scope would be. We would work internally amongst all the different divisions. Each division head would sit at a table, what we call the Regulatory Development Committee, hash out all the different aspects of that rule. We would identify a person that is kind of the lead, that would have the most experience at that. Once we have established a rule that we feel is good for stakeholder process, we would have identified funding mechanisms, how to implement it, how to enforce it, what the authority would be, and all those items that this current petition does not have. We would then bring it out to a stakeholder process. We would reach out to them, sit down at the table, discuss that, and then when there's common consensus about that rule in the petition, then we would file it with the Air Board. Does that answer your question?
Yes, thank you, Deputy. And then so specifically for the mapping requirement in EHD's perspective, where it states that it could implement it within 60 days, if this was something that EHD was filing for the board's consideration, would it already have certainty that it could meet that 60-day deadline before it even floated the idea with the board?
That is correct. Again, at that time, if based on our concepts at that time, it was a number we felt we could meet. However, yes, to your question, we would have definitely identified any kind of tool, any kind of mapping, any kind of obligation by the department that we were going to put upon ourselves that we could meet those obligations and meet it financially and time-wise.
Thank you. That's all.
Thank you. I see Member Lewis raised your hand again.
I'm sorry, I do have one more point of clarification. I think it's important for the deliberation process. And it has to do with definition, Mr. Albrecht. And I've heard the word stakeholder engagement and stakeholder involvement and getting input from stakeholders. And I've also heard a lot of terminology around public notice and public meetings. Could you define for me what those processes mean to you? Who's involved in the stakeholder process and who would be the participants in a public process? And I think those terms are being used differently than I'm familiar with in my professional capacity, and that's why I want the clarity. Thank you.
So, so you're asking a question what the definition of a stakeholder process is versus stakeholder process, in our view, would be that period of time where, and I'll use the rule, this current rule is, and I won't use the petitioner's example, I'll use the department's example. If we got to a point where the regulation we felt is at a good point where we could go public with it, we would reach out to stakeholders being, it could be the community, it could be the businesses, it could be other federal government, other federal entities. And I think more importantly is what hasn't been really shared, and it just came to my mind, is we would reach out to the state. We would reach out to the state environment department. I would reach out to EPA and state and let them know, hey, we are going to be looking at, well, I'll just use a very generic term, an EJ permitting rule. What are your thoughts on it? We would provide EPA with actually a draft of it as well. We would reach out to the NMED Air Quality Bureau and provide them a draft of it. So stakeholders, it encompasses the public. It could engage the business community, concerned citizens, coalitions, all the above. And, you know, the stakeholders, that definition can change every day.
And that would be at the point you already had a draft, correct?
If we, okay, I'll use the example for our, if it was our rule, if we had a draft that we felt comfortable with, and we felt it was pretty well polished, knowing that it's going to get, you know, it's going to get reviewed, it's going to be beat up, and there's going to be concessions made. Yes, we would actually identify those stakeholders. We would have put it out to our listserv. We would have put it out to all of our, anything there's opt-in for air quality notifications, we would, through Air Board or whatever, we would have engaged that process.
Thank you.
Was that it, Member Lewis?
Yes, I'm sorry.
Thank you, Member Lewis. You're done, Mr. Albrecht. Thank you very much.
Thank you.
Any miscellaneous matters before we consider the evidence closed? All right, we're going to take a 10-minute.
Mr. Hearing Officer, just one minor. When we talked about some of the federal regs, I just wanted to see if we could get the board to take notice of the federal hazardous air pollutant program, particularly the delegation to New Mexico and to the city of Albuquerque under 40 CFR.
If it's part of the record, they will consider it.
I don't believe it is. I just wanted to make sure that the board's aware that 40 CFR 63.9 A32 outlines the federal program and what portions of the federal hazardous air pollutant programs have been delegated to this board and to the city.
As I stated, if it's part of the record, they'll consider it. If it's not, you cannot interject at this point, just as Ms. Semino's research and report cannot be considered at this late juncture?
I believe the board can take administrative notice of it spells out the requirements. So I believe the board can take notice of that in its deliberation without it having been offered as an exhibit.
They can draw on that, I'm sure. Anything further? We're going to take no more than a 10-minute break. We had talked about closing arguments. I think the board is leaning towards 5 minutes for each party. We've got about 10 parties here. I may allow Ms. Richards an extra 2 minutes because she's arguing also for the U.S. Air Force and Kirtland Air Force Base. But whatever we decide, it's going to be somewhere between 5 and 10 minutes per party. So. And we'll take that up during this 10-minute break, no more. I'm going to give the court reporter a much needed break.